There were two main issues in front of the court in this case. The first issue was whether it was okay to restrict the applicant's right to a lawyer, so whether there were compelling reasons for doing so. The second issue was whether the evidence obtained from the applicant's statements during their first police interviews could be used against them in court. The facts of the case go back to July 2005, when a series of terrorist attacks happened on the London transportation system. This was called the biggest terrorist attack in the history of England, where 52 people were killed and about 700 people were injured. The facts of this case actually concern the attack that happened 2 weeks after the famous London bombing, and it involved a similar attack on the public transport system, but with bombs that did not detonate at the end, so nobody was killed or injured in this event. However, the attackers, or the suicide attackers, they fled from the scene, so nobody was arrested in the beginning. 6 days later, the police arrested the first suspect of the case, who was traced thanks to the CCTV images. At that moment, the police knew nothing about whether there were other bombs planted at other places, or what were the plans of the alleged terrorists, or whether he had any other co-perpetrators. This person was taken to the police station, and he was detained incommunicado, so he was not allowed to meet with his lawyer or any other person, in accordance with the regulations on terrorist cases that existed at that time in England. He was questioned for 4 hours. In the beginning, he then asked for a lawyer, but his request to have a lawyer was refused. In total, I think he was questioned for about 6 hours without ever speaking with his lawyer. Again, the reasons for denying access to a lawyer were fully in line with the legislation that existed in England and Wales at that time, and that is still in force in this country. 2 days later, 2 other persons were arrested, and their detention and questioning followed the same pattern. So they were not allowed to speak with a lawyer before or during the interview, although in this case their lawyers were notified in the beginning of their arrest, and they've actually requested to speak with the suspects, but the police did not let them in, saying that the suspects had to be questioned had to be questioned in the beginning before, without access to a lawyer, again citing the same terrorism-related provisions. So the question before the court was whether it was okay to delay access to a lawyer to these 3 suspects in the beginning of the proceedings, so whether there were so-called compelling reasons to delay access to a lawyer, and whether the evidence obtained during the interviews before the suspects have had access to a lawyer could be used in the trial against them. So what would you think if you were confronted with a situation like this? The majority of the European Court of Human Rights, and this was already a Grand Chamber decision, has held that indeed it was okay to limit access to a lawyer for these 3 suspects in the beginning of the proceedings, during the first interviews. Their reasoning was that this was necessary in the interests of investigation, that there was possibly an imminent threat or risk to lives in this particular situation, and that the police had to prioritize the operative needs of conducting an urgent inquiry over organizing access to legal assistance. So if we read the majority judgment, we might think that the reasons that are given are quite compelling and quite good and quite comprehensive. However, if you read the dissenting opinion in this case, which was delivered by judges Chayo and Lafranc, you might start doubting whether the majority judgment was so flawless and so convincing as you might think. Actually, the court didn't explain why not admitting the lawyer in this case would endanger the person's lives or the interests of the ongoing investigation. There's two possible reasons, there's two possible justifications as to why not admitting lawyers in this case could be justified. The first one is the timing issue. So if you admit a lawyer, this would delay the questioning and the investigation. This reason doesn't really apply in this case because, as I mentioned before, lawyers were already notified about the arrest and they were available to consult with the suspects. The second reason would be that the so-called risk of collusion, so the risk that the lawyer, admitting a lawyer would result in a leak of information to the third parties. However, this justification is not legitimate because in that case we would assume that lawyers would inevitably conduct in an unethical way and they would share the results of the investigation with the third persons in such a particularly sensitive case as this one. In conclusion, in my opinion, the court in this case failed to justify in a convincing way that there were necessary and compelling reasons to restrict access to a lawyer to the applicants in the first police interviews.
So now let me tell you about the second issue of Ibrahim case, which is the question whether the statements made in violation of the right to counsel should be used for a person's conviction or not. Imagine this case. It's a high-profile murder case. A student has been killed and the police has no clue who the murderer is. After a long investigation, they finally get, for some reason, interested in his or her fellow student, maybe a flatmate. And this person is arrested, taken into police station where he or she is interrogated in a very intense manner. Maybe there are long interrogation hours. He or she is physically or psychologically pressured, but he or she claims his innocence and demands for a lawyer. No lawyer is granted, and finally, after exhausting interrogation, he or she confesses. We don't know whether this confession is true or not, but we know that there was a lot of pressure. According to my research in the EU, in 5 member states, these statements would actually be used for this person's conviction. In 23 member states, these statements would be excluded. But in 19 member states, these statements would actually still be brought to the eyes of the deciding court, because they would be in one way or the other retained in the case file. So basically only in 4 member states these statements would be totally excluded. So this is the status quo in the member states, and the question is how it could be like that. So the successor of Ibrahim case was Saldus versus Turkey. In that case, the court said about the exclusion of evidence, quote, "Rights of the defense would in principle be irretrievably prejudiced when incriminating statements made during police interrogation without access to a lawyer were used for conviction." Now, the Ibrahim case, the application of exclusionary rule, it all came down to the term "in principle", and the Ibrahim court said that "in principle" means that this is a rule, but it's not automatic rule, it's a rule with exceptions. Also, the judges Shayo and Lafranc emphasized in their partly concurring and partly dissenting opinion that the exclusionary rule that comes from Saldus is automatic, and they based their argumentation on the meaning of "in principle", which they say that in standard dictionaries it means it's a rule, not it's a rule with exceptions. But despite of that, Ibrahim case still created the overall fairness proceedings test, which means that the evidence could be used for conviction anyway if the proceedings as a whole was fair. The problem for the EU is that there is a directive 2013/48 on access to lawyer, and in this directive, in Article 12, there is also a right for remedy. So in principle, when your right to counsel is violated, you will have a remedy according to that directive. But the problem is that the wording of the Article 12 is very vague, and its interpretation should be based on the case law of the European Court of Human Rights. The directive was drafted when the Saldus, with its automatic exclusionary rule, was in force. Now there is Ibrahim with overall fairness of the proceedings, which in principle means that member states don't have to include exclusionary rule into their law. Of course, the counter argument for that is that in the directive, Saldus is explicitly mentioned, which means that the directive should still be interpreted in the light of Saldus, not Ibrahim. But we don't know how it will be in the court practice of the ECJ. If we interpret the directive in the light of Ibrahim, it means that the member states don't have to include the exclusionary rule to their national system. Therefore, the statements made in violation of the right to counsel can be used for a person's conviction. But in these cases, can we actually conclude that in these member states the right to counsel is exercised? Ibrahim is a drawback not only to the case law of the European Court of Human Rights, but also to the EU legislation. The member states who were, in the light of Saldus, supposed to change their remedy system and include the exclusionary rule will now not do that, which means that still there will be member states in which the statements received in violation of the right to counsel will be effectively used for persons' conviction.